Okay, we start inshallah. Bismillah ar-Rahman ar-Rahim. Alhamdulillah, salatu wassalamu ala Rasulillah. My name is Khaled Alqazzaz and I'm the Executive Director of CMPAC, Canadian Muslim Public Affairs Council. And today we're facilitated a webinar to discuss Bill C-9, the Combating Hate Bill introduced by the Liberal government and being pushed quickly into the Parliament and is being discussed next week in the committee. I am honored to have with us one of the experts on these issues and on privacy issues and on lots of issues that impact our civil liberties. Tim McSorley, who's the national coordinator of the ICLMG, the International Civil Liberties Monitoring Group, who is an advocate and a champion really for our civil liberties and has basically good awareness of the different issues that impact our liberties, our freedoms, with different multiple legislations being introduced. Today we're going to discuss Bill C-9 specifically. Tim will go through the details of the bill. What does the bill talk about, and why is it really of concern for all civil liberties communities? I will basically follow with advocacy actions that we can take in order to basically improve the situation, stop that bill in this current form, and basically advocate for for our rights and freedoms as well. Before I begin, I would like to just give a bit of an introduction on the political context and the environment where this bill came to existence. And because it's very important, like any legislation, any piece of legislation, any political action stems out of a political context and a political environment. And Bill C-9 particularly is a bill that came in a very difficult time. It came post October 7th, and it came in a very polarized environment. It came after a liberal government that won 3 elections and had to change its leadership, had to force Justin Trudeau out and introduce Prime Minister Carney to take the party to a new direction. And part of the failures of the previous government that was acknowledged was the way they handled the genocide in Gaza and the way they basically mishandled the whole situation, and to some extent were complicit in supporting the genocide in different ways, and these are attempts and discussions that were made over the past couple of years. Prime Minister Carney accepted the leadership position or ran through the leadership race and led the party into a quick snap elections. And in this election, he continued with the same Liberal Party approach to appeal to different communities. And hidden somewhere in the Liberal Party's agenda, the Liberal Party had a promise of a legislation that will combat hate. And most definitely, everybody in the civil liberties sector and the Muslim community leadership and the entire Muslim community are definitely at the forefront of combating hate. They are basically they are on the receiving end of hate from different parts of society and institutionally, unfortunately, sometimes. And they are the first to advocate for ways to reduce or to eliminate hate against Muslims and against all communities. So we're coming to this conversation, we're coming to this place of action from a position where we prioritize combating hate. However, there is almost a unanimous agreement in the civil liberties sector and among Muslim community leadership who are involved in this space that this bill does not really offer protection, and it is more about limitation of freedom of speech and freedom of expression. And here comes the context. So the context is that this was a direct promise of the Liberal Party to the pro-Zionist community to basically balance some of the actions that they gave for the towards Palestine, like the promise of state recognition and some of the limitations on the permits for arms sale to Israel. So so this was the promise for a specific community, and basically it was presented in the guise of that this is not against protest, but it is mostly against it's for combating hate. The details of the legislation was kept like unclear for quite a long time, and this premise of anti-hate was the one that was communicated to parliament members, to different communities, and so on. However, when the legislation came to existence and people started to have access to it, it was very clear that there are many aspects that actually limit freedom of expression and could be viewed that it is directed, that it can be used to limit particularly pro-Palestinian protests, pro-Palestinian expression in general. And interestingly, the bill was announced by the Liberal Party after after a meeting that Prime Minister Carney has had with the pro-Zionist lobby and members of the Jewish community, where they announced after that meeting that they are committed to that promise and that they are going to go through with it. And within a week, that bill was introduced in Parliament. It passed two readings very quickly, and then now it is being pushed to committee and is going to be discussed next week. This is how fast the legislation have moved forward, and this is how tied it is to the political context that it was created in. The civil society sector got alarmed after they viewed the bill, had technical meetings with the Justice Department that has introduced, the Justice Minister has introduced the bill. We have assembled together, put a joint letter to Minister of Justice rejecting the bill, led by CCLA, India Civil Liberties Association, and then another statement from the Muslim community, basically also rejecting the bill. So this is the situation we're in. The bigger challenge really from an awareness perspective is people are unaware of the details of the bill. What does it entail? What does it talk about? And how is it going to be used? And with that, we're pleased to introduce Tim McSorley, the national coordinator of the International Civil Liberties Monitoring Group, who's gone through thorough analysis of this bill and is ready to share with us, to walk us through this bill and share with us some of the concerns around this bill. We'll follow this with a few actions that we are asking of everyone and related to advocacy, and then we'll open the floor for questions. You can ask the questions basically at the YouTube on the YouTube chat, or for some of the members here on Zoom. With this, on to Tim McSorley.
Great, thanks so much, Khaled. It's great to be here. Thanks for inviting me, and thanks for that introduction. And definitely, we share the concerns that you raised about the context in which this bill is coming. And I hope by going through some of the aspects of the bill and the parts of the bill will make it clear why there's so many concerns that we share with CMPAC and so many others around Bill C-9. So just because I want to walk people through the bill, I've created some slides just to help guide us. So I'll just call that up. And oh, just 1 second. It doesn't seem to be there. Oh, here it is. Okay. Sorry about that. Okay, hopefully everyone can see that now. Um, so yeah, thanks again, Khaled. As you said, I'm with the International Civil Liberties Monitoring Group. We're a coalition of 45 organizations, including CMPAC, Canadian organizations, that work to defend civil liberties in Canada from the impact specifically of anti-terrorism and national security laws. And a lot of that has to do with defending the right to free expression, to free speech, and to dissent. But I also want to make it clear that through our work, especially with our members from faith-based organizations and other groups, including Christian, Muslim, Jewish organizations, who are all members of ICLMG, that we recognize and we've seen the rise in hate-motivated violence and actions across the country. It's something that we share a lot of concern with and believe that more needs to be done to address this. But we're concerned with the government's approach to it, and particularly around Bill C-9 and how, as I think will become clear, that while overall there are concerns with each part of the bill, that by linking some of these provisions that would limit free expression and free speech to some other provisions are more clearly, whether we agree with them or not, directed to combating hate crimes. That it's raised a lot of questions around why these are linked together and the government's intentions by trying to pass this through as one piece of legislation. So with that, I'll move on to some more of the context with the bill. So it's officially the Combating Hate Act. It was introduced, as Khaled said, in late September, and it's already moving quickly through Parliament. And as we said, officially, it's a government response in rise in hate crimes across Canada. But I won't go into too much, but just to emphasize what Khaled said about how it's raised some serious concerns across sectors and communities. And I want to emphasize that joint letter that Khaled mentioned that was spearheaded by the Canadian Civil Liberties Association. It brought together the Canadian Labour Congress, the Centre for Free Expression, ourselves, the Black Legal Action Center, and Independent Jewish Voices, and a total of 37 groups that all raised shared concerns around what the impacts of this bill will be. So it isn't simply, and sometimes these bills are are portrayed, and opposition to the bills are portrayed as, one community versus another in order to say, well, it's people who are concerned about privacy, but they don't understand concerns around hate speech and racism, or vice versa. And I think what this is really showing through the work that CMPAC is doing and the work that the CCLA is doing, that it's cross-cutting concerns across many different sectors and groups around what the impacts of this bill would be, and why there's legitimate reasons to be concerned about what this bill would do if it passes. So just to go over what exactly is in Bill C-9, there's 5 main components to the bill, and you can see them on the screen right now. I won't go through them all right now because I'll go through each one of them as we go forward. But it isn't a very long bill, but there's a lot of implications to it. So I hope we can get through those and have a chance to discuss some of the reasons why we're concerned, and also take some questions at the end. So one of the areas of greatest concern are new provisions that would create an offense of the willful promotion of hatred by displaying symbols in a public place. And so what this would do is that it would create an offense, a criminal offense, that if you display a symbol that is principally used by or principally associated with a listed terrorist entity, as defined in the criminal code, the Nazi Hakenkreuz, or swastika, or the double sig rune, or any symbol that so nearly resembles a symbol described above that's likely to be confused with that symbol. And so that's a really important aspect, and I'll get into that in a second. And so at first glance, really, this would seem maybe obvious that, well, why wouldn't we want to ban people from being able to promote hatred through the display and public display of these kinds of symbols? But it really comes down to the broad and vague nature of what the government is proposing here. So first off, the government is linking this offense to the terrorist entities list. And there's the terrorist entities list isn't a neutral and isn't an obvious or non-controversial tool. The list itself is mired, and the listing process is mired in secrecy and in concerns around how it can be used in politicized and discretionary ways. One thing that people have pointed out is that there's a disproportionate representation of organizations that are accused of engaging in terrorism, but that are tied to Palestinian liberation. It has also included other organizations that throughout history have been accused of being involved in terrorism, but that have now become parts of peace processes and recognized as having been standing up for self-determination. Um, and for example, the people have made clear that if the ANC and Nelson Mandela were fighting today against apartheid in South Africa, that they would be listed on the terrorist entities list because they would be included in its definition. And so there's a lot of concerns around who gets listed, how they get listed, and the fact that it's very difficult to challenge a listing once you're placed on it. And so by tying the list of symbols to listed terrorist entities, it kind of builds upon that questionable and controversial system. Um, and it also means that it's on one hand overly inclusive by including groups that are that there's arguments and debates about whether or not they should be considered on the list, and others that aren't included on the list. So, for example, if groups that have engaged historically in anti-Black racism, such as a Ku Klux Klan or other organizations, are not listed as terrorist entities. And we would argue that we should be expanding the list, but that would mean that this new provision wouldn't apply to things like the display of the Confederate flag in order to promote hatred, or to displays of other symbols such as a noose or things like that that have historically been used to portray and invoke hatred against Black communities. And so this is incredibly problematic. Um, and it's only compounded by the issue of what is considered resembling a symbol. And so it would place on the onus of police to determine when they're out at a protest, when people are displaying signs and flags and various things like that, to determine what is a terrorist entity symbol and what is associated with them and what resembles that symbol. And so one of the concerns that we have is that it could be applied very broadly. And we know that in the current context of anti-genocide protests, that symbols such as the kafia, other flags that have, for example, Arabic writing on them that maybe those such as myself who do not read Arabic wouldn't know what it says, but that could be conflated and confounded with, or that we've seen bad faith arguments in order to try to denounce and undermine anti-genocide and pro-Palestinian protests by conflating their efforts with support for terrorism. And so it would place this power in the hands of police to determine in the moment whether or not a symbol is associated with, which is a very broad term, a listed terrorist entity, or that it could be a riff or a version of a symbol that's associated with a terrorist entity. And that simply places too much discretionary power in the hands of police. And the worry is that they would then use as an excuse to go in and arrest people, stop them from protesting, break up protests that are otherwise peaceful, under the assumption that there could be a link to a terrorist entity, a terrorist symbol, but that it may never actually lead to a charge, would never stand up in court, but that it's basically used as a way to chill dissent and free expression that would otherwise that's otherwise considered legal. It's also redundant based on the fact that there's already an offense of the willful promotion of hatred. And so by adding the symbols to it, the government argues it adds clarity for police, but as just been explaining, it actually opens up a whole area of vagueness and lack of clarity. Um, but that also police already have the power to charge somebody with a willful promotion of hatred, and they could take into account already the fact that somebody is using a symbol in order to promote hatred. And so at the same time as this introducing a lot of vagueness and discretionary decision making, it's also redundant with existing laws. So I'll move on to the next provision, and that's the creation of a new standalone hate crime. And I think that this is, there's debate around the effectiveness and necessity of this provision, but this is probably the part of the bill that's most directly related to actually addressing the rise in hate crimes in Canada. It isn't without controversy, though, because well, first of all, and this is not the controversial part, but just to make clear that as part of this bill and this new offense, it would codify the definition of hate as set out by the Supreme Court of Canada. There's some discussion around whether or not this is close enough. There's some small differences between this definition and what the Supreme Court has said in some of their rulings. But essentially, it would codify in law for the first time a definition of hatred. But what it would do, and that's raised more concern, is that creates a parallel hate offense for any other offense enacted by Parliament. So, for example, if you engage in, uh, you know, a crime that's accused as mischief, or vandalism, for example, you will be charged with that vandalism crime. But then, if there's a belief that that there was a hate motivation to it, then you could also be charged at the same time by a second offense for that hate offense. So you would essentially be facing two charges when you go to court. And the penalty for the hate offense would be in line with the original offense. So if the vandalism charge comes with a possibility of 2 to 5 years of imprisonment, this is just for example. I'm not saying that's what a vandalism charge comes with, but if that were to be the case, then you could face 2 to 5 years additional charge for it being a hate offense. And so this, for the first time, would be there would be a separate specific hate offense in the criminal code. And while there's been a lot of calls for a standalone hate offense in order to ensure that there's a recognition of the harm that hate offenses have on society, and that it needs to be treated severely and taken seriously. There's some concerns around how this will play out in reality. So, for example, right now, hate motivation is already considered an aggravating factor at sentencing. So, if you commit a crime that is motivated by hatred, it's not like that there isn't anything the government could do or that prosecutors could do in order to take that into account, but rather it would come in at the end, so that the judge would be able to decide based on what's proven throughout the court case, and at the end, if it was motivated by hatred, they would be able to take that into account to impose a greater sentence than they would otherwise. There's concerns that it risks a duplicative punishment, so that by creating two offenses, you would be charged with one offense and face a penalty for that, but then you would also face a penalty for the other offense, which demonstrates the seriousness of the crime, but it could very well lead to excessive and disproportionate sentencing. And by bringing in hate charges right at the beginning, it frames the accused as having engaged in hate speech or a hate activity all throughout the criminal process. And so there may be greater pressure for them to settle in order to have a lesser sentence and to avoid having to go through that long process. And it could also kind of taint the perception of the actual crime itself. And so there's concerns that, that this part of the bill should have been a standalone bill that could be debated and decided upon in depth, but that by putting it into the middle of a bill that deals with the hate symbols, as well as I'll get to next, these new intimidation and obstruction offenses, that it kind of blurs the impact and motivation for the different components of this bill. And kind of sets it up in a situation where if you're against the other parts of the bill as well, then it looks like you're against taking action to address hate crimes. Um, and so we're concerned about how the government has approached just politically the introduction of this bill and its different components. Next are the new offenses for intimidation or obstruction of the use of a place used by an identifiable group. It sounds vague, and I hope to make this as clear as possible because it is a very concerning part of the bill and could have some very wide-ranging impacts. And so just to lay out what it says in the bill is that it would create two new offenses. One of them would be an offense for conduct with the intent to provoke fear in a person in order to impede their access to a building or structure or part of a building or structure that's primarily used for religious worship. So a synagogue, a mosque, a temple, or a church, etc. Or that's used by an identifiable group, and I'll get into what that consists of in a moment, um, for various purposes, including administrative, social, cultural, or sports activities, as an educational institution, or daycare center, or a residence for seniors. Or finally, any attempt to provoke fear to prevent somebody's access to a cemetery. Um, as an example of what has been given for what these buildings, apart from religious worship institutions and cemeteries, could be, it would be buildings or institutions that are primarily used by an identifiable group. So it could be a religious school. So a school, so an Islamic school or a Jewish or Christian school, a daycare center that's geared specifically towards a particular community, or for example, a cultural building that's run for and caters towards a particular group. So to make that a little bit more clear, what an identifiable group is defined in the criminal code, and it's any section of the public distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, gender identity or expression, or mental or physical disability. And these are also what's essentially covered by other hate crime provisions already, in terms of an identifiable group. And when we talk about groups that are protected under the charter, this is generally what we mean. So apart from the offense as I mentioned, this offense to intimidate and provoke fear, there's a follow-up offense around obstruction or interference. So if you were to obstruct or interfere with a person's lawful access to any one of those buildings or structures mentioned earlier, then that would also be considered an offense. And either the intimidation or the obstruction offense would have a maximum penalty of 10 years, or also punishable by summary conviction. So I know that's a lot of information. I'll try to kind of summarize and break down what it means in the next part. So the goal, according to the government and what's laid out, is that it would be that they could use this in situations where people are holding a protest or essentially a protest or any kind of event action outside of one of these institutions, where the intent is to provoke fear to stop somebody from being able to use it. So the example in a briefing this morning, in fact, that we had with Justice was, for example, if a group of people wearing masks are standing outside a mosque or synagogue holding rocks and intimidating people into not going in. But our concern with that is that, that obviously that would be concerning to anybody. But we already know from the policing of protests that we've seen over the past 2 years and in general, whether or not it's for Palestine or student strikes, or environmental protests, protests against economic equality or for gender rights, that police have a broad range of tools already in order to take action against somebody who's brandishing a rock in order to threaten somebody at a protest. And so there's a concern that there are already laws in place that could address any kind of intimidation, harassment, obstruction outside of structures and geared to and targeting people, and that we don't need a whole new layer of legislation in order to address that. And so on top of that, there's concern about what's meant by and what would be included by by the structures that are protected under this legislation. And so, again, at first glance, it would make sense that a church, a mosque, a synagogue, or temple would be, you know, protected from obstruction and harassment and threats. And that's true. Um, but there's also the concern that these buildings don't 24 hours a day, 7 days a week, only serve that one religious worship purpose. And what we've seen is that there are events held in these institutions and at these at any kind of building that could go beyond and not follow that principal use. So, for example, the example that's come up is that there have been protests outside of synagogues in the past 2 years where there's been real estate deals, real estate events to sell land in the occupied in the occupied territories of the West Bank, which is illegal under humanitarian under international law. And so the worry would be that this law would apply to any use of these buildings, even if it's not for those religious or cultural purposes. And that would then mean that individuals would be barred from engaging in protests or could be charged with these intimidation or harassment offenses, even if what's being protested is a political event and one that provokes public debate and opposition legitimately. So I know we have to move on, so I'll wrap up very quickly. There's also just in general a concern that, again, this is broad discretionary powers for the police, including their ability to determine, what is a state of fear, and around, in what circumstances should this law be applied. The very last thing is there's concerns about the removal of Attorney General consent for the laying of hate propaganda charges. And that essentially just means that right now the Attorney General needs to approve charges. Without that in place, it's a safeguard that's gone that could allow for more vexatious private prosecutions, and also would allow for police to pursue charges that maybe don't have a good chance of holding up in court. And again, plays into this concern and adds to this concern of discretionary and vague decision making by law enforcement. So I'll leave it there. I'm sorry. I think I went a little bit longer than I meant to, but I hope that does give a good overview of why we're concerned about this bill, what some of the points are that's brought groups together in opposition to it, and what needs to be changed. And to be clear, there could be some amendments made that could improve some parts, but fundamentally, we and others are calling for the bill to be withdrawn, because overall, large parts of it are already covered by parts of the criminal code, and the cost that could bring in terms of the chill on free expression and dissent and free speech, including the ability for groups that are considered identifiable groups and that have engaged in protest and push and actions to defend their rights and protect their rights, would also be negatively impacted by this new legislation if it were to pass. So I'll leave it there, and thanks so much for having me today, Khaled, to speak about this.
Thank you, Tim, so much for this presentation, for this thorough presentation. It's a great overview of the bill and the concerns with each segment of the bill. And I understand it's a lot to take, but I think an easy takeaway that the civil liberties groups that came together basically conclude that this bill in its entirety is problematic. It does not solve the problem, and it is redundant when it comes to there are other legislations, other part of the criminal act that actually deals with the issues that this bill is attempting to resolve, and it unfortunately adds more authority to law enforcement with less checks and balances, less regulations, which really, for those who were on the streets for the past couple of years, or those who are involved in protests across, are actually understand what does this even mean from an intimidation perspective, or abuse of that extended authority. More interestingly, and Tim is aware that this is beyond what was promised in terms of protection and legislation. And it seems advocacy in the opposite direction managed to add a few pieces to a legislation that was meant to really, initially, the intent that was communicated to us and other faith groups, that it was meant to protect religious spaces. So it went far and beyond. It redefined hate. It added an independent hate offense. Has nothing directly to do with the protection of spaces. Expanded the idea of what does it mean to be these buildings. So it's not only religious buildings. It expanded the scope of what kind of activities that religious institutions used to do. So beyond religious activities. So it really, this is a blanket bill that unfortunately could be easily abused, could be really weaponized to, and I'm using political terms, Tim was carefully using legal terms, so it can be easily weaponized really to chill protest, to chill expression in directions that and to chill dissent in all possible ways. So and the risky part here, it is not just basically similar to the like it is more serious than even the bubbles laws, because the bubbles laws at the end of the day it's an infraction and a fee that is being paid and an event that is stopped. This one here is a criminal offense, and it is a compounded criminal offense, and more concerning when the Minister of Justice was asked last week, will this extend to online space? He confirmed that yes, it can be extended to online space. So really, it goes beyond protection of space and targeting expression in different ways, and it is intentionally using vague terms such as a special offense related to instilling fear in people, that same offense, that same section that talks about buildings and obstruction of buildings. One part is actual obstruction, but the other part is basically people instilling fear in people to access these buildings, which means really as a vague interpretation that it can be used in like many ways that will be very problematic. And we understand that there are even additional definitions that are tied to other campaigns that can, when compounded with this particular legislation, will be even more problematic. So we explained the political intent of this bill, and there is no hiding that this bill was meant to reward a community that is advocating, as the Zionist community that was advocating for this bill. We spoke about the legislative challenges with this bill and its impact on our charter rights and freedoms. And we spoke about the potential impact and concerns of this bill. So really, what can we do? And I think this is the remaining few minutes that we will share with you here. And I will also ask Tim to contribute here. So from an institutional capacity, the organizations clearly on the civil liberties side and on the Muslim community side clearly came out and said, we reject this bill, and we put these reasoning. Our organization CMPAC on our website, we even put a detailed analysis of why is it problematic. Similarly, CCLA has a multiple analysis on this particular bill. So the organizational and the professional backing of why this bill is problematic is out there. Really, in a very short time, the challenge is to communicate as extensive as possible that this is a bill that is not going to hurt the Muslim community or the pro-Palestinian community, that is going to impact everybody's rights and freedoms, right to express and right to assemble, and basically even right to dissent. So really, as Tim started, it is not just about one. This is a call out from the community that is meant to protect our rights and freedoms, and we need to echo this. Okay, so one is really echo that this is not acceptable, and we need to address the problem of hate, but this is the wrong direction. The second request really is to communicate this to politicians. So in our engagement with politicians, especially the liberal ones, this was sold to them as if it was really a protection bill for, against hate, and it is clearly not. Maybe an original version was, but this one is clearly not. So we anybody with a connection, or at least their connection with their elected official, should reach out to them and tell them that this is an unacceptable bill. We have a campaign, an email campaign on our website, and we have a like, you can just simply click on the link, and Simran, you can add the link here. They can go to and email their MP immediately to tell them that this is something that they not accept. The second is we have an in-person visit campaign, a day of action tomorrow. If you this week the MPs are in their constituency offices, so you can actually go and actually express this clearly. You can take CCLA statement, you can take the Muslim community statement, and basically show them that you are with this position and you are against it. So these are direct actions. One is that you publicly say on your social media, in your whatever space that you're in, that this is something that is worrisome to you, worrisome to your community, and you're against it. Two is you communicate to your elected officials. We don't want the impression that this is acceptable or anything of this sort. And then number three, I personally think, and we as an organization, as CMPAC, feel we have a collective duty as communities to reduce the tension, to reduce polarization, to actually combat hate, right? And but we don't have to do this through legislation. I think community leadership, community initiatives, conversations, dialogue, serious attempts to really reduce the tension. The pro-Palestinian community, the pro-Palestinian protest, particularly over the past couple of years, demonstrated clearly that their intent, their direction is entirely towards what's happening, the genocide that is happening in Palestine, in Gaza specifically. It is not directed towards a specific community here or specific individuals. It's directed there and against the complicity of the government here. Very legitimate complaint. It is not meant to intimidate anyone. So, but we understand that also with this polarized environment, the hate sentiment has risen. Our community has seen additional Islamophobia. The Jewish community has seen additional anti-Semitism, and at exponential rates. But I think actions that attempt to fuel more polarization, such as this legislation, is actually counterproductive. And we really need to lead initiatives that actually reduce the tension, explain our intents, reinforce our commitment to our rights and freedoms. I think this is what is needed at this point. So express this, say this, propagate this, push this across your networks. This is going to affect your rights. It's going to affect your children's rights. It's going to affect people not just in religious spaces but beyond religious spaces. So we really encourage you to do as much as you can to communicate in public and to your elected officials. So this is what we have, and the campaigns are active and running, and they're going to be shared on YouTube and going to be shared here, and they are on our website, CanadianMuslimPAC.ca, CanadianMuslimPAC.ca. Tim, do you have anything to add on advocacy and what can be done?
Thanks, Khaled. I think you covered it really well. I just want to emphasize that I agree that now is the time that we need to be reaching out to members of parliament, reaching out to people in our communities, and reaching out across communities to be sharing, our concerns with this legislation. We have an action on our website too at iclmg.ca that folks can use to write to their MPs and to the government to raise concerns. And I think what you were saying, Khaled, that there's a context of where this came from, and that is, to push this idea that there has been somehow an under policing of pro-Palestinian anti-genocide protests, when what we have seen is the complete opposite. That even with the existing powers that police have, that they have engaged in the over policing of these protests and rallies. arresting people, by breaking them up, by shutting down encampments on campuses and things like that. And so the idea that we're going to be safer by bringing in these new powers, and that it's actually going to help to foster and to lower polarization and division between communities is completely false. And I think it's important that we think about how this can be used in the future, or how it could have been used in the past. And there's such a degree of discretionary powers for the police in here, that really, going forward, that you know uh, cultural institutions are used to really host hate mongers, fear mongers, people who this bill are supposed to, this bill ostensibly is to push back against, that they could be protected from protest and protected from people speaking out in the future. And so, I think it's really important that that's made clear that there is a context to this bill, but that its impacts will be wide ranging if it's adopted, and that it's really is a very concerning and cynical attempt by the government to bring in these anti-protest and anti-free speech bills or powers in the context or under the guise of combating hate. And yeah, just really appreciate everything you share, Khaled, and that we're working with our members across the coalition right now to make sure that people are that we're reaching out to our MPs. Um, and if there are people who work with different organizations that are concerned about this bill, there's still time to write to the committee that's studying the bill, to write to MPs, and to get involved. And I'm sure you can reach out to Khaled or to ourselves at ICLMG to talk about how we can work together.
Thanks, Tim. We'll open the floor for questions. I think there was a question asking, are we talking about Bill C? Is this only about Bill C-9 or Bill C-2? So there is a whole other campaign for Bill C-2. And Tim, if you can also share some resources about Bill C-2, which is also another problematic bill that the government is pushing quite quickly. However, there was some resistance to Bill C2, and it's now split to two bills. Uh, but it is also it also has some it has a lot of implications and concerns. But today we're discussing Bill C9. Uh, so there is a question here. My MP Wade Cheng is a newly elected backbencher who hasn't responded to anything I've sent him, and whose assistant have indicated that he won't meet with me due to an enormous backlog of requests. Any suggestions? So I'll take this, Tim. So yes, MPs in principle should give time to their constituents. If you can't speak to them directly, you can attend events that they organize on other occasions. You can also, what I recommend is that you go to the MP office and hand deliver a note from you or a statement that you support. This is what we recommend. And speak to the staffers who are there. They will summarize and show. And if there are 20 people who go to the office at different times or at the same time, they will take note of this and will take it. And when you go in person, also request a meeting with the MP, and they should follow up and at least give you a date. Tim, do you want to say anything here?
Just to add that, phone calls are very effective too. It's obviously the most effective is going in person, but they need to log these things, and they keep a log, and it's noted within the parties when they receive phone calls and visits on certain issues. And so it is really important that to recognize that, every visit, every phone call really does help to build the momentum, and that they take note more so than emails, or I think the work that I think we do at ICMG and CMPAC are important, but sometimes they dismiss the idea of organizations and whether or not we're speaking for the communities that we work with. And so for individuals who are the voters, who are the constituents of MPs to go forward, has a lot more impact. And so I just say, don't underestimate what your phone call or what your visit, even if you don't get a chance to speak with the MP, it does have an impact. And right now we need that impact to spread not just across the Liberal Party, but across all the parties. Because right now there's really only the NDP MPs, and there are only a small group right now in Parliament who are speaking out forcefully about the bill. And we need to make sure that the message is heard across the parties.
Thanks, Tim. So the question is if CMPAC is aware about Bill C2 and C8. Yes, it is part of our advocacy and part of our sessions. There was a previous webinar organized previously about Bill C2 through one of the other, I think, was it you, Tim, who organized the Bill C2 webinar some time ago? And can you also share the links for people to be more informed? So these are some of the legislative work. So we're working in sync, and we're part of the coalition under ICLMG as well to work against any legislation and any policy that basically attempts to limit our freedoms or invades our privacy, or basically returns the dial really to darker times. I want to just comment here also on the advocacy is also like the every time requires a specific type of advocacy. So this is the time where the government is trying to rush this through very fast. So it is important to send a clear message to the government that you cannot really mask this bill under protection. So from our community, you have to send a clear from all other communities. We don't see this as protection. It is not protection. It defeats the purpose, and it basically affects our freedom. So we're against it. So this is the time that this has to be clearly communicated to MPs, and it is clearly you have to communicate to your MP that you are going to really watch their action and record how they react as it relates to this bill, because this bill affects you, your children's future, and everybody. So, and it's not just a Muslim community issue or a pro-Palestinian community issue, it's everyone. So it is important to note that the MPs know that we as constituents are actually noting down their action, specifically on this bill. And it cannot pass under it was a campaign promise. It cannot pass under well, I have to vote with the party. No, on many issues, and particularly in freedoms and rights, charter protected rights and freedoms, there is an individual obligation that the members of parliament actually stand up against this, representing the interests of their constituents as well. So really, I think this is the time now. As this moves forward, so maybe other parties might ask to make changes, make amendments. When things change, if the situation of the bill as its form, we're rejecting it. If things change, we will come together and discuss it and suggest alternate courses of action. Push for if there is room to push amendments, then we're going to reorganize and discuss what is the best strategy. As long as it's in Parliament, the action is to get the MPs from all parties to resist this. If this goes beyond into implementation, then we have other avenues for advocacy primarily, and many legal groups will take this to a charter challenge because it is really in violation of our charter rights. So there is going to be legal advocacy post this, and in parallel, this is a kind of legislation where every incident counts. So if the law is used or abused, it is very important to record, to track every case. As the Justice Minister said, is a case that is going to set precedent to it's a case by case implementation. So we have to be very cautious and very alarmed as communities, and watching and show them that we're watching how this bill is going to be implemented. And the advocacy is going to be at the level of those who implement this legislation. If police authorities are abusing this, then our advocacy goes towards police authorities at the municipal level, at the regional level, and so on. So this is a journey. It is not a one-time thing. So even if it passes quickly, we're not stopping. Even if it goes through amendments, we're not going to stop and we're not going to pause. But our community, people who are watching, people who are following, needs to be part of this. This is not something for Khaled and Tim, ICLMG, CMPAC, NCCM, others to just, this is not our issue. This is everybody's issue. and more voices advocating are going to be more impactful on this legislation. And I reiterate that this is not against that we are for combating hate, but this is not the right way. Any other questions? Let me just check the YouTube. I don't see more questions here. Okay, I don't see more questions. Tim, do you have any final words or remarks?
No, I think you summarized it really well. And just to emphasize, as you said, that this is, there's an immediacy to it now, but there's going to be a longer campaign around as the bill keeps going through the House and then goes to the Senate to push for it to be withdrawn or, changes if necessary, as well as, if it does pass, to push back against the repercussions that will come. And just to say that, we like you, we're very concerned and believe that there needs to be clear actions, both from the government and at a community level to address polarization, division, and the rise in hatred. But that this bill is not the way to accomplish it, and that we're open to talking with the government and working with others to to find those solutions. But that this bill, the dangers that it poses just so greatly outweigh any benefit that could come from it in terms of combating the rise in hate crimes, that it needs to be opposed.
Thank you so much, Tim, for your time. Thank you for going through this thoroughly and helping us understand the bill and the concerns and suggesting some actions that can be practically taken at the right time. So the right time is actually now. So please join the campaigns, whether the email campaign that was shared with you earlier, or the day of action, or simply express your frustration and rejection of this bill on your social media in your contacts, and please communicate this to your MP in the best way possible. Stay tuned to our campaigns and messaging on our CMPAC website, Canadian Muslim Public Affairs Council, CanadianMuslimPAC.ca, and our social media channels at CMPAC online, or subscribe to our WhatsApp groups, and you will be informed about this bill and other bills that we are advocating for. Thank you all for your time. Wish you all the best, and we look forward to seeing this bill removed or totally changed. Thank you so much, and have a great evening. Bye bye. Assalamu alaikum.
Thanks, Khaled. Night, everybody.